Welcome to Talk Trials.
It's good to be here.
Today, we are settling in for a serious, granular examination of the appellate process for our veterans. We are acting as your guides to a professional Federal Circuit Court of Appeals opinion analysis.
That's right. Our mission, as always, is to take a stack of complex legal documentation, the opinions, briefs, statutes, and really just extract the most important nuggets of insight.
We want to get you to that aha moment without all the overwhelm of the legalese.
Precisely. We are here to bridge that gap between the raw text of a judicial opinion and the practical realities of what happens in legal practice. We take the legalese and hopefully turn it into logic.
And today, the case we're looking at is Robert M. Laird v. Douglas A. Collins, Secretary of Veterans Affairs.
This is case number 2024-1263. The decision came down just recently, December 17th, 2025.
This case was heard by a panel of circuit judges Lori, Schall, and Stoll.
And Judge Stoll authored the opinion for the court.
Now, on the surface, if you just glance at the docket, this might look like a pretty standard procedural dismissal. It's a short opinion. It's non-precedential.
Right.
But when you really start to peel back the layers here, there is a tremendous amount of tension. A tension regarding how the courts handle mistakes.
Mistakes by everyone involved. Both by the veteran and by the system itself. It really is a masterclass in the boundaries of the court system.
It is. It forces us to ask, where is that line drawn between correcting an injustice and, just adhering to the strict rules of procedure?
Which is a question that comes up over and over again in this area of law.
So let's frame the core inquiry for everyone listening. What are we really looking at today?
Well, the big question is whether the Federal Circuit even has the power, the jurisdiction, to review a lower court's decision that an error was harmless.
The harmless error doctrine.
Okay. And coupled right with that, we have to talk about timing. Specifically, whether an argument that's raised for the very first time in a motion for reconsideration, is it considered preserved for appeal, or does it just vanish into the ether of waivers?
It's a classic confrontation. On one side, you've got the substantive rights of a veteran who is seeking benefits.
And on the other, you have these rigid, almost mechanical procedural walls of the federal appellate system. It's a brick wall for many.
Okay, let's unpack this. Before we get into the weeds of the timeline and the forms, and there are forms, give us the bottom line. Let's start at the end. What happened to Mr. Laird's appeal?
The bottom line is that the Federal Circuit dismissed the appeal.
Okay, so they didn't affirm the lower court? They didn't reverse it?
No, they simply dismissed it. And that distinction really matters. They didn't look at the merits of the case and say the lower court was right.
Right.
They essentially said, we do not have the ticket to hear this case. We can't even enter the room.
And why is that? What was the rationale for saying we can't even look at this?
The core rationale is jurisdiction. It's all about jurisdiction. The court determined that Mr. Laird's appeal was essentially challenging the Veterans Court's application of law to fact.
Okay, application of law to fact. Break that down for us.
Sure. So the Veterans Court had decided that an error made by the Board of Veterans' Appeals was harmless. The Federal Circuit held that reviewing that specific determination, whether an error is harmless in a very specific factual context, that falls outside their limited jurisdiction. It's a line drawn in the sand by statute.
So because it involves looking at the specific facts of Mr. Laird's case to see if the error actually mattered, the Federal Circuit says, hands off.
Exactly. They're saying we are a law court, not a fact court. But, there's a secondary rationale here that is just as important, especially for practitioners to understand.
And what is that?
The court noted that the appellant's specific argument, the one about the effect of the board's error, was waived.
Waived. The dreaded W word in appellate practice.
Indeed. It's a killer. The court found it was waived because he didn't raise that specific argument until he filed a motion for reconsideration at the lower court.
Wow. So you not only have a jurisdictional bar, but a procedural one too. It's a 1-2 punch.
It is a complete knockout.
It feels like a tonal reflection here is necessary.
Yeah.
You mentioned this is a non-precedential disposition. Does that mean it doesn't matter? Should people just ignore this?
Oh, not at all. No. It means it doesn't set a binding precedent for future cases, sure. But what it does is it highlights the incredibly strict procedural boundaries and jurisdictional limits facing veterans.
It's a warning shot.
It's a huge warning sign. You can be right about the error. The court can even agree with you that an error was made. But if you don't argue the harm of that error at the right time, or if you ask the wrong court to review the facts, the door just slams shut.
A warning sign that procedure can be just as deadly as the substance of the case.
Oh,
Okay, let's rewind. Let's see how we got to this point. We need to go strictly into the factual background. Who is Robert M. Laird?
Robert M. Laird is a Marine Corps veteran, and his journey through this whole VA appeals system began quite a while ago. We have to go back to 2010.
2010, okay.
That's when he filed a claim for service connection for post-traumatic stress disorder, or PTSD.
So, 2010, he files for PTSD. That is the starting gun. What happens next?
Well, the machinery of the VA starts turning slowly. In June 2011, he goes in for a VA medical exam. Now, pay close attention to this because this exam is absolutely critical to everything that happens later.
It's the pivot point.
It's the pivot point of the evidence, exactly.
Why is this exam so important? What did it say?
Because the results were mixed. On one hand, the examiner diagnosed him with major depressive disorder, or MDD.
Okay.
However, and this is the key part, the examiner explicitly stated that Laird did not have PTSD.
So he goes in asking for PTSD connection. He gets an exam, and the doctor comes back and says, no, it's not PTSD. But you do have depression.
Correct. So following that exam, in November of 2011, the Agency of Original Jurisdiction, that's the local VA office, they issued a decision.
And what did they decide?
They granted service connection for the major depressive disorder based on that diagnosis from the June exam.
So he got connected for something.
He did. They assigned him a 10% disability rating.
10%. Okay, so he's on the board. He has a 10% rating for depression, but he originally wanted the PTSD connection, and I'm guessing a 10% rating wasn't what he was hoping for.
Right. And this is where the procedural snare catches him. This is the moment everything goes sideways. We move forward to October 12, 2012.
And what happens then?
Mr. Laird is representing himself at this point. He's acting pro se, and he submits a document to the VA.
And what was the intent of this document he sent in?
His intent was to file what's called a Notice of Disagreement, or NOD. He wanted to request an increased rating for his condition. He was essentially appealing the previous finding, saying, I disagree with that 10% rating.
But I feel a but coming.
But he used the wrong administrative form.
The wrong form? Oh, no. That sounds like such a minor bureaucratic detail. Oh, you used Form A instead of Form B. But in administrative law, forms, they can be everything, can't they?
They certainly can be. And in this case, it was fatal. Because he used the wrong form, the Board of Veterans' Appeals did not view this document as a notice of disagreement regarding the PTSD denial or the MDD rating.
So what did they see it as?
They interpreted it as a new claim for an increased rating for MDB.
Wait, hold on. Explain that difference, because it sounds subtle, but I'm guessing it's huge. Instead of saying, I disagree with your decision from last year, the board read it as, I am filing a brand new request for an increase starting right now.
Precisely. And that distinction, that single distinction between a continuous appeal via a NOD and a new claim, it changes the entire legal landscape of his case.
How so?
It changes the timeline, it changes the potential back pay, and most importantly for this case, it changed the evidence that the board is allowed to look at.
Let's dig into that. Why does it matter so much? What are the specific consequences of the board's interpretation of that form?
It all comes down to something called the look-back period. This is governed by statute and regulations. When you file a new claim for an increase, the scope of the evidentiary review is limited by law.
Limited how? What are the blinders?
The board only reviews evidence from the date of that new claim and the one-year period preceding the submission.
Okay, I see where this is going. If it's a new claim that he filed in October 2012, they are legally required to strictly look at the window from October 2011 to October 2012.
Exactly. Now, you remember when that critical medical exam took place?
June 2011.
Right, June 2011. That date falls outside of that one-year look-back period if the filing is treated as a new claim filed in October 2012.
Oh, wow. So because of the form he used, the single most pivotal piece of medical evidence, the one that established the diagnosis in the first place, is potentially cut out of the review for that specific claim.
Crucially, yes. The board is legally prevented from considering it in that context. That time frame potentially excluded that June 2011 exam from the specific review.
But if it had been treated correctly as a notice of disagreement?
If it had been a NOD, a continuous appeal, the record would remain open all the way back to the original decision. That exam would be squarely in play for any arguments about the proper rating or the effective date.
So because of how they interpreted the form, the board eventually denied an earlier effective date. They basically said, we're starting the clock right here in October 2012, based on the limited evidence they were allowed to review.
That is the crux of the board's decision on August 2nd, 2022. It took that long They treated it as a new claim, they applied the limited look back, and they denied the earlier effective date.
So after a decade, Laird finally gets this decision, and he appeals this to the Veterans Court, the Court of Appeals for Veterans Claims. And this is where things get really interesting, because he actually wins an argument here, doesn't he?
He does. The Veterans Court analyzes that first layer of appellate review. They looked at that document he filed way back in 2012, and they agreed with Laird.
On what point?
They held that because he was pro-C representing himself, his submission should have been liberally construed as a valid notice of disagreement.
So they gave him a break because he wasn't a lawyer.
Essentially, yes.
Yep.
They explicitly held that the board erred. The board made a legal mistake in determining otherwise.
So, victory. The board was wrong. It was a notice of disagreement. He used the wrong form, but the court said, it's close enough. We know what you meant. A moment of common sense.
It was a victory on the error, but it was a defeat on the outcome. And this is where we get the introduction of the harmless error doctrine.
The legal equivalent of no harm, no foul.
Essentially, despite finding that the board committed a clear legal error by misidentifying the document, the Veterans Court concluded that this error was harmless.
How can an error like that possibly be harmless? It shifted the whole timeline. It excluded the key piece of evidence.
Their reasoning was that the board had ultimately left the October 12, 2012 effective date intact. And the court noted that in his initial brief to them, Laird did not attempt to challenge the finding as to the date entitlement arose.
So they're saying, yes, the board made a mistake, but you haven't shown us in your paperwork, in your brief, how that mistake actually changed the result regarding the date.
Correct. They affirmed the board's decision despite the error because, in their view, the veteran hadn't connected the dots. He hadn't explained the prejudice caused by the error.
Now, imagine being Mr. Laird or his current counsel at this point. You get a decision that says, you were right, the board messed up, but you still lose. That has to be incredibly frustrating.
Absolutely. So they scrambled to correct the record, and this leads us to the motion for reconsideration.
This is the pivotal procedural moment. Laird files a motion for reconsideration with the Veterans Court. He tries to explain exactly why the error wasn't harmless.
He's trying to connect the dots that the court said were missing.
And what was his argument in this motion? What was the dot he was trying to connect?
His argument was exactly what we just discussed. He said, because the board treated my filing as a new claim, they limited the scope of evidence, the look-back period, which wrongly excluded that crucial June 2011 exam.
He's spelling it out.
He is. He's saying if they had treated it as a continuous appeal, a NOD, that exam would have been part of the review, and it could have potentially supported a higher rating or an earlier effective date.
That seems like a solid, logical argument. It directly connects the dot between the wrong form and the missing evidence. It explains the harm.
It is a logical argument, but the Veterans Court denied the motion. They refused to even entertain it.
Why? If the logic holds up, why not hear it? This seems like the moment to correct the record.
Because it was new. The court stated that Laird relied entirely on legal arguments not presented in his initial brief.
You can't wait until you lose the game to explain the rules you were playing by.
That's a good way to put it. You can't wait until you lose the case to explain why you should have won. The court's response was, effectively, you're too late.
You're too late. And that brings us finally to the Federal Circuit. Laird appeals the Veterans Court's decision to dismiss his motion and affirm the board. And now we have this opinion from Judge Stoll.
Right. And the Federal Circuit analysis really breaks down into two main obstacles for Mr. Laird: jurisdiction and waiver. Let's start with that statutory wall of jurisdiction.
We hear this so often in veterans cases. The Federal Circuit has a very, very specific lane. They aren't just a super appeals court that gets to retry the whole case.
They are not. Their jurisdiction is strictly defined by statute, 38 U.S.C. Section 7292. Subsection D1 tells us what the Federal Circuit can review.
And what is that?
Relevant questions of law, constitutional interpretations.
Okay, so pure legal questions. Things like, what does this statute mean? Is this regulation constitutional? Did the lower court misinterpret the legal definition of service connection?
Exactly. Pure legal interpretation. But then you have subsection D2, which is the wall. It tells us what they cannot review.
Thou shalt not.
The thou shalt not. They cannot review a challenge to a factual determination or, and this is the key phrase, a challenge to a law or regulation as applied to the facts of a particular case.
And how did the court apply that specific phrase to the Laird case?
Well, the court cited a key precedent, Pitts v. Shinseki. They looked at Laird's argument, which was that the board's mischaracterization of his form led to a restricted evidence review. The Federal Circuit didn't view this as a pure question of law.
What did they see it as?
They viewed it as a challenge to the Veterans Court's determination that the error was harmless.
So determining if an error is harmless involves looking at the facts. Is that the idea?
Necessarily. To decide if an error is harmless, what do you have to do? You have to look at the record. You have to look at the evidence that was excluded, in this case, that June 2011 exam.
You have to look at the timeline.
You have to look at the timeline.
Right.
And you have to weigh whether including that evidence would have changed the outcome. That entire process is the very definition of applying law to fact.
So the Federal Circuit is saying, in order to agree with you, Mr. Laird, we would have to pull out that June 2011 exam, read it, and decide for ourselves if it matters. And Congress told us in a statute that we are not allowed to do that.
That is precisely the holding. They concluded that reviewing the harmless error determination is outside their jurisdiction. And that is the number one reason for the dismissal.
So they effectively said, we can't even look at this because it requires us to do fact-checking that Congress has forbidden us from doing.
That's right. But then, as if that wasn't enough, they twisted the knife a little bit with the secondary analysis on waiver.
Right, the timing issue, the too late argument. So even if they could look at it, they said they wouldn't.
Correct. The court highlighted that the argument regarding the specific effect of the error, the exclusion of the June 2011 exam because of the look-back period, was not raised until the motion for reconsideration.
And they cited a case here, Bluebonnet.
Yes, Bluebonnet Savings Bank v. United States. It's a foundational case for this principle. It sets the standard that arguments made for the first time in a motion for reconsideration are too late.
It's a hard and fast rule.
It is. They are deemed waived, and they are not preserved for appeal. Period.
So it effectively means the court system is saying, you had your chance, you had your one shot to tell us this in your first brief, and you missed it.
And it creates a very rigid structure. The appellate process is not designed to be an iterative conversation where you get to add new reasons as you go along. You absolutely must present your full case, your full theory of harm in your initial brief.
You know, here is where it gets really interesting for me, and I think for our listeners who practice in this area. We're talking about a system that is supposed to be pro-veteran, right?
That's the mantra.
We have this whole concept of liberal construction for pro-se veterans, which the Veterans Court even used to help Mr. Laird on the form issue. But these rules, jurisdiction and waivers, they seem incredibly, almost cruelly rigid.
And that leads us perfectly into the legal context and significance of a case like this. We really need to discuss the boundaries of review.
It just feels like there's a fundamental tension here, a tension between wanting to help veterans get a fair shake and wanting to maintain a strict, efficient judicial hierarchy.
There is. And the Federal Circuit's jurisdiction in veterans' appeals is, by design, strictly limited by Congress. We see this reinforced time and again in cases like Harmless v. Shinseki. The statute is written to prevent the Federal Circuit from relitigating the specific factual nuances of every single veteran's claim.
But why is that specifically excluded? I mean, why can't the Federal Circuit just double-check the facts to make sure justice is done in a case that seems so procedurally unfair?
It's a matter of judicial economy and really the designated role of each court. The Veterans Court, the CAVC, is the specialized court. It's designed to handle the factual record. They're the ones who are supposed to dig through the medical files and the service records.
They're the fact finders.
They are the expert fact finders in the system. The Federal Circuit, on the other hand, is a generalist appellate court. You have to remember, they handle patents, international trade, government contracts, and veterans' appeals. They're meant to settle broad legal questions that apply across the board, not get bogged down in individual factual disputes.
So if the Federal Circuit had to reweigh the evidence in every case to see if an error was harmless, their docket would just grind to a complete halt.
Exactly. They would effectively become a second veterans court, which is not what Congress intended when it set up this two-tiered review system. So by saying application of law to fact is off limits, they are protecting the system's efficiency and structure, even if it feels harsh in an individual case like Laird's.
But the other big lesson here is about what you called procedural hygiene and litigation.
Procedural hygiene. I like that phrase. It sounds a lot cleaner than don't mess up your paperwork. But it's just as vital.
And the lesson for practitioners here especially regarding the Waiver doctrine. It just can't be overstated.
You absolutely must raise all fears of harm in the initial brief before the Veterans Court. You cannot assume the court will connect the dots for you, even if it seems obvious.
You can't just say the board made an error. That's not enough.
No, that's step one. You have to say, the board made an error. Andy, here is exactly how it hurt my client. Here's the evidence that was excluded. Here is the benefit that was lost. Here is the money that wasn't paid.
And you certainly cannot wait for a motion for reconsideration to explain why the lower court's error mattered.
The danger of waiting is fatal to the appeal. It's not a maybe, it's a definite. Once that judgment is entered, the record is effectively closed to new legal theories. You don't get a second bite at the apple.
It also just highlights this incredible difficulty of pro se filings versus these rigid procedural rules. I mean, Laird won the liberal construction argument. The court cut him slack on using the wrong form because he was representing himself.
Yes, and that's an important principle. The liberal construction doctrine helps pro se veterans get their foot in the door. It allowed that 2012 document to be read as a NOD, which is a huge win. But once you're in the formal appellate phase, especially when you're dealing with foundational concepts like waiver and jurisdiction, the rules become rigid again for everyone.
So liberal construction of a pleading does not equal liberal application of appellate jurisdiction.
That is a crucial distinction. You can get a break on what you wrote on a form 10 years ago, but you don't get a break on the statutory limits of the federal circuit today.
Precisely. And that brings us to the point in our deep dive where we step back from the specific opinion and look at it through our own lens.
That's right. It is time for the 10th chair.
And just a reminder for our listeners, the 10th chair is our segment where we imagine we are the extra judge on the panel. This is our independent, reasoned analysis for discussion. It is not legal advice.
Now, sitting as the 10th chair, if we were on that panel or perhaps reviewing this case on back with the whole court, how would we vote?
What is the judgment?
The 10th chair votes to affirm the dismissal.
Affirm the dismissal. That is a tough pill to swallow for the veteran, especially given the whole wrong form saga. But walk us through the reasoning for that vote.
It really comes down to two unbreakable principles. The first is jurisdictional fidelity. While the result is, frankly, very unfortunate for this veteran, the 10th chair argues that the Federal Circuit is statutorily bound by 38 U.S.C. Section 7292 to...
You can't just rewrite the statute from the bench because you don't like the outcome in one case.
You can't. To rule otherwise, to say, you know what, we are going to review this harmless error finding, would require the court to reweigh the facts. They would have to look at that 2011 exam, analyze the timeline, and decide for themselves if the limited look-back period actually changed the outcome. And that is a task that is explicitly, not implicitly, but explicitly forbidden by Congress. The court cannot expand its own jurisdiction.
So even if you want to help, the law says you can't touch the facts. That door is locked and bolted.
Correct. But there's a second prong to the 10th chair's reasoning, and it's just as strong. It's the waiver dispositive.
The bluebonnet issue.
Exactly. Even if you could somehow stretch jurisdiction, and I don't think you can, the bluebonnet precedent is insurmountable. The entire judicial system relies on arguments being presented at the proper stage. Why? To allow the lower court, in this case, the Veterans Court, to address them fully in the first instance.
If you allow arguments to be raised for the first time in reconsideration, you're essentially asking for a do-over every single time someone loses.
It would disrupt the finality and the efficiency of the entire appellate process. If the Federal Circuit allowed this, it would incentivize practitioners to hold back arguments or at least be sloppy with their initial briefs, knowing they can just fix it later in reconsideration. That's not a precedent the court can possibly set.
It effectively tells lawyers, and by extension their clients, do your homework the first time. Get it right.
Yes. It reinforces the integrity of the adversarial process. The court is a neutral arbiter. It is not there to cure the defects in your argument after the fact.
So given that reasoning, what's the projected impact of a ruling like this? What's the takeaway message?
It serves as a stark warning. It reinforces the fatal nature of failing to plead prejudice effectively in the initial brief. It's a siren, a blinking red light for counsel who are assuming cases from pro se veterans.
So when you, as a lawyer, take over a case that has this long, messy pro se history, you have to look for these procedural landmines immediately.
Immediately. You must identify and argue all prejudicial effects of any prior errors before the Veterans Court judgment is entered. You absolutely cannot rely on fixing it later. The window of opportunity is incredibly small.
It's a harsh lesson, a really harsh lesson, but a necessary one for the integrity of the system as it's currently constructed.
Indeed.
So let's wrap this up. To summarize our deep dive today, Laird v. Collins results in a dismissal from the Federal Circuit.
And the key takeaways are crystal clear. First, the Federal Circuit lacks jurisdiction to review harmless error determinations because they are, by their nature, an application of law to fact. And perhaps more practically for anyone listening, arguments raised for the first time in a motion for reconsideration are waived. They are gone.
It is a case that turned on a wrong form being used in 2012 and ended on a missing argument in a brief in 2024. A very long road with a very sudden stop.
It's a powerful reminder that in law, especially administrative and appellate law, process is often just as powerful as substance.
Remember, our analysis, including the judgment offered in the 10th chair, is commentary for informational and discussion purposes only. It is not legal advice and does not represent the actual holding or views of the Federal Circuit.
We always encourage you to read the full opinion for yourself and come to your own conclusions.
And on that note, we'd love to hear your thoughts on this. I mean, does the strict application of the waiver doctrine punish veterans and their counsel too harshly? Or is this kind of procedural rigidity absolutely necessary for the courts to function efficiently? Let us know.
Until next time.
This has been Talk Trials. Thanks for listening.